This is Barry Zalma speaking for Claim School Incorporated's video blog, Zalma on Insurance. Today we're going to talk about why there must be strict compliance with promissory warranties and why a promissory warranty in a policy must be fulfilled. There is never coverage available under a marine policy if there is a breach of a promissory warranty. Ralph Young owned and lived on a 74-foot motor-operated vessel named the Summer Star. Mr. Young insured the vessel with Yachtinsure Services, Inc. from 2013 to 2019. On August 28, 2019, the vessel ran aground and was destroyed when Hurricane Dorian hit St. Thomas in the United States Virgin Islands, where the vessel was moored. Yachtinsure rejected the abandonment and denied Mr. Young's claim based on what it considered his material misrepresentations in his April 2019 policy renewal application. As a result, the USDC was asked to resolve an issue of voidability of a marine insurance policy under principles of federal maritime law. The insured pursued a claim for breach of contract against the insurer based on the insurer's refusal to pay for damages sustained by plaintiff's insured vessel during a hurricane in August of 2019. In a case entitled Transpac Marine versus Yachtinsure Services, a February 13, 2023 decision of the United States District Court for the District of Massachusetts, the court followed the precedent establishing the inviolability of a promissory warranty. Yachtinsure asserted counterclaims for declaratory judgment, seeking judgment that Mr. Young's insurance policy was void as a matter of law and that Yachtinsure had no obligation to pay damages or the benefits promised by the policy. On April 16, 2019, Mr. Young applied for the renewal of his marine insurance policy to Yachtinsure to renew the existing policy. Mr. Young was obligated to submit an updated application form and a hurricane plan for review by Yachtinsure's underwriters. The hurricane plan included a warranty that Mr. Young made that the vessel will be secured with 10 lines 3/4-inch nylon braid. The applicant was warned that the hurricane plan, quote, contains statements upon which underwriters will rely in deciding to accept this insurance, close quote, and that the hurricane plan, quote, will form the basis of, close quote, any insurance contract between the parties. The declaration also stated that misrepresentations or non-disclosure of material facts, quote, may entitle the underwriters to void the insurance, close quote. After an inquiry from the insurer, Mr. Young confirmed that in the event of a named or numbered storm, mooring lines would be doubled. Mr. Young's email representation that he would double the mooring lines on the vessel in the event of a named windstorm was incorporated into his policy agreement with Yachtinsure. During an examination under oath after the vessel was destroyed, Mr. Young testified he decided to sail to Crown Bay in St. Thomas, U.S. Virgin Islands, where the storm was expected to pass with wind speeds below 30 miles per hour. Mr. Young resolved to wait out the storm. On August 26, he purchased 2 new 1-inch diameter mooring lines from the local chandler in preparation for the storm. Beyond securing the vessel with these 2 additional mooring lines and moving upholstery below deck, Mr. Young made no further safety preparation. On August 28, 2019, the storm, by then named Hurricane Dorian, changed its trajectory and struck the Virgin Islands. By the time he learned that the storm would hit the Virgin Islands, Mr. Young determined sailing away from the Virgin Islands to be unsafe. Instead, he decided to remain moored to a single mooring in Crown Bay, secured by 6 lines, 4 of unspecified diameter and 2 of 1-inch diameter. Just after noon, high winds from Hurricane Dorian parted Mr. Young's mooring lines, causing the vessel to drift out to sea. However, the anchor's chain became entangled with a sailboat operated by a third-party mariner, Dan Radlewitz. Thereafter, as alleged, Mr. Radlewitz disconnected Mr. Young's anchor gear, causing the Summer Star to be swept up in the storm. The vessel eventually ran aground on the lee shore about 4 miles from Crown Bay. Mr. Young was airlifted from the wreck by the United States Coast Guard. Mr. Young filed a claim declaration with Yachtinsure on September 3, 2019. The court considered the precedent of the Supreme Court that held in Norfolk versus Kirby that federal law controls the contract interpretation of a marine insurance policy when the contractual dispute at issue is not inherently local, and observed that the First Circuit has held that there is a judicially established federal rule governing the particular area of marine insurance contract interpretation relevant to the case brought by Mr. Young. Whether an insured's representations in the policy constitute unambiguous promissory warranties which, if breached, excuse the insurer from coverage. The court found that the hurricane plan was unambiguous. The plain language of Mr. Young's answer to question 15 cannot reasonably be read to convey anything other than Mr. Young would use 10 lines of 3/4-inch nylon braid to secure the vessel. Mr. Young's response to question number 15 of the hurricane plan states unambiguously, he will secure the vessel with the configuration of mooring lines he specified in his response to the questions on the application. Mr. Young responded to the hurricane plan with what is in essence a stipulation that he would secure the Summer Star with the mooring configuration he identified when the policy took effect and during its continuance. Thus, this provision of the hurricane plan constitutes an unambiguous promissory warranty to secure the Summer Star with 10 nylon mooring lines that were 3/4 inches in diameter in normal circumstances, and with 20 such lines in a named and numbered storm. Under both federal law and New York law, a breach of a promissory warranty will permit the insurer to void a marine insurance contract. Simply material compliance will not satisfy the insured's obligation. The weight of authority holds this strict compliance requirement applicable even to collateral warranties unrelated to the insured's claims for damages. The court concluded that Yachtinsure established beyond reasonable factual dispute that Mr. Young failed to meet his obligation of strict compliance with his warranties under the hurricane plan, and Mr. Young's admission that he did not use 23/4-inch nylon braid lines to secure his boat during Hurricane Dorian and thereby satisfy a prophylactic condition the policy called for is sufficient to prevent him from recovering under the policy, and as a result, summary judgment was granted to Yachtinsure. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and will be advised of every blog posting, usually 5, sometimes 6 a week. And you can also have access to the more than 4,550 blog posts. You can also view the videos on rumble.com and youtube.com, and you can subscribe to those videos free of charge. And if you like what you see, please click on the like button on YouTube and the thumbs up button on rumble.com. And if you are interested in further detail on insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing to my Substack publications or my locals community. Thank you for your attention.